To give us the welcome remarks, I'd like to call on Dean Danilo L. Concepcion of the UP College of Law.
Magandang hapon po sa inyong lahat. It is indeed an honor for me to welcome all of you to the 10th UP Law Centennial Lecture. For this afternoon's lecture, it is entitled Concerns and Emerging Trends in Related Laws on Family and Children. We are very privileged to have as our lecturer the Venerable Justice Flerida Ruth Pineda Romero. Kabisado ko yung buong pangalan ni Ma'am kasi teacher ko po siya. You know, when I entered law school, magkakabistuhan na ng edad. In 1979, the first class in the morning that we attended was the class of Mrs. Romero in Persons and Family Relations. Alas 8 ng umaga yan. Si Ma'am, siguro mga 5 minutes before 8, papasok na ng kwarto yan. Close the door. Sabihin na, Ma'am, sirado na yung pinto. Ito na si Concepcion, late. Makatok. And then papasok. Mr. Concepcion, you're late. You have to sing or else I will not allow you in. Pinakanta mo mamakunot. Hindi mo alam, gusto ko naman kumanta. So I sang before the start of our class. And being under Justice Romero is not only enjoyable, it was not only enjoyable, it was fruitful, very fruitful. Without a doubt, Justice Romero's distinguished years of service in the judiciary and in the academe have given her unparalleled experience and insights in the field of family law. Changing attitudes and technological advances are challenging the traditional notions of gender, marriage, and family. Procedures that once could only be found in the realm of sciences and fiction, such as in vitro fertilization, artificial insemination, and surrogate pregnancy, have proven to be viable alternative means of procreation. Developments in DNA testing would revolutionize our concepts of paternity and filiation. Alam niyo, nung araw, pag sinabi ng misis ninyo, anak mo to, maniwala ka. It's an act of faith. Pag sinabi niyang anak mo to, maski kahawig ng driver ninyo yan, anak mo yan. Okay. But maybe kasi wala namang DNA nung araw, during our time, wala pang DNA noon. When we were studying under Justice Romero, blood grouping test lang ang available at that time. Hindi pa nakakarating sa Pilipinas yung DNA testing, although it was already existing at that time. Divorce is now legal in every country in the world, almost every country in the world, with the Philippines as one of those very few where divorce is not yet a law. Same-sex marriages are already recognized in several jurisdictions, and such couples are allowed even to adopt and raise children as their own. Hindi naman sila pwede magkaanak, Ma'am, maski anong gawin nila. These trends, as well as several others, raise questions on the relevance and applicability of our current system of family law. These trends apply pressure for reforms ranging from minor amendments of individual laws to a complete revamp of the legal system. Thus, we are fortunate to have someone of Justice Romero's caliber to shed light on the impact of these trends on our family law and the manner through which these laws can adapt to changing technology and norms. Without much delay, we welcome all of you to the College of Law Centennial celebration. Thank you very much.
Dean Danilo Concepcion already gave us a glimpse of our lecturer for this afternoon. But to give us a more detailed introduction of our lecturer on the concerns and emerging trends in related laws on family and children, I'd like to call on Professor Patricia Salvador Daway to introduce our lecturer.
Thank you very much, Prof. Gigi Reyes. Good afternoon, one and all, especially my dear mentor, my counselor, my friend, my boss, my ninang, all rolled into one. It is indeed a privilege for me, an honor, to present to you, to introduce to you this afternoon our speaker, a member of the UP College of Law Centennial Commission, no other than the Honorable Flerida Ruth Pineda Romero. Justice Romero, who comes, by the way, from the celebrated class of 1952, including our former lecturer about 2 weeks ago, and the likes of Vice President Laurel, Senate President, and dear Justice Fernan, and many others. Okay. Justice Romero is one who would not sit on her laurels. Soon after her retirement from the Supreme Court, a senior associate justice, and for many years, the only lady justice for 6 years, I think from the year 1993 until her retirement. She was the lone lady justice of the Supreme Court. Okay? So soon after that, she accepted a position as judge in the Administrative Tribunal of the International Labor Organization, holding offices in Geneva from the year 2000 until 2005. She was the first Filipino and first lady judge of the ILO Administrative Tribunal. And at the same time, she also accepted a judgeship, presiding judge of the Administrative Tribunal of the Asian Development Bank. This was from the year 2004 until 2006. Earlier, of course, she had a very fruitful stint as the justice of the Supreme Court of the Philippines at the time when, it was really an honor to be a justice of the Supreme Court. No doubt, no scintilla, no iota of doubt. Okay. She rose to become the chairman of its 3rd division. Ma'am Romero also held positions in the executive department. She was the special assistant to dearly beloved President Corazon C. Aquino from 1987 until her elevation to the Supreme Court in 1991. Concurrently, she held on to the position of Presidential Legislative Liaison Officer to the Senate. Ma'am Romero, prior to that, was the Secretary General of the Constitutional Commission. So in each copy of your 1987 Constitution, you find there the name of Ma'am Romero as its Secretary General. In the academe, Ma'am Romero was our dearly beloved professor in persons and family relations, in obligations and contracts. She went on, of course, to be appointed as a regent, a member of the Board of Regents of the University of the Philippines, the apex of her career in the academe. Earlier than that, she was director of the UP Law Center, the director. There was no associate dean at that point in time. So Ma'am Romero headed the UP Law Center from 1979 to 1985. It was at this point in time when Ma'am Romero led us in a lot of trailblazing activities at the UP Law Center in 5 areas. Okay? One is continuing legal and judicial education. There was no IBP at that time, no PhilJA, nothing. So it was all Ma'am Romero. Second area was popularizing the law. Third was in utilizing the media for legal education. Okay? Fourth was in the area of labor education. Fifth was in elevating the status of Filipino women through law. In continuing legal and judicial education, Ma'am Romero earned the distinction of being the pioneer in continuing legal education for lawyers and judges alike. As head of the UP Law Center's Division of Continuing Legal Education from 1965 to 1979, 14 long years. And as the center's director from 1979 to 1985, so a total of how many years? 20 years. She designed and implemented legal programs and seminars in various fields of law, judicial conferences, advanced courses for judges of different levels, even the bar review classes, okay, and conferences on legal education. And for this, the Law Center, of course, received a lot of accolades. In popularizing the law, Pop Law, I heard this term for the first time as a student from Ma'am Romero. To familiarize the people themselves on their basic rights and responsibilities as well as their legal remedies, Ma'am Romero launched a program on popularizing the law. So through the barangays, the NGOs, and high schools, she, and of course with the able assistance of her staff at the UP Law Center, reached out to the barrio folk, the grassroots, and the students. And for this, the UP Law Center was again conferred many awards. In the area of utilizing the media for legal education, Ma'am Romero decided to utilize the radio, just like our Dean, Dan Concepcion. But of course, it's tele-radio now. Ma'am, not just radio. To disseminate legal information to the end that the people may not be victims of injustice. In the area of labor education, okay, now you know where I got my love for labor law. A pilot project of the U.S. Philippine governments in the 1950s, Ma'am Romero pioneered in offering various kinds of training programs and seminars, first to labor leaders, and later to those first to labor leaders in the Philippines and then to those in other areas in the entire Asian region to promote not only democracy but also responsible leadership in the ranks of labor leaders. In the area of elevating the status of Filipino women through law, Ma'am Romero, after having attended the very first International Women's Year in 1975 in Mexico, together with, among many others, the late Justice Cecilia Munoz Palma and the late Dean Justice Irene Cortez, Ma'am Romero mobilized the entire UP Law Center to launch a campaign to accord women full equality with men before the law by, among many others, chairing the Family Law Revision Committee, which became the Civil Code Revision Committee headed by Justice J.B.L. Reyes. This committee drafted for 7 years what came to be known as the Family Code, your EO number 209 of 1987, which amended the anachronistic provisions relegating Filipino women to a status subordinate and inferior to men and earning for Ma'am the title Mother of the Family Code. Mother of the Family Code. No, so now, students, you know who the Mother of the Family Code is. And so without further ado, I really have the honor to present to you one who has been consistent honor student from her elementary years until her high school, college years. She was class valedictorian, elementary class valedictorian, high school, on consistent honor student in the University of the Philippines. So it is my distinct honor to present to you a lady who is soft-spoken, gentle, cannot say any harsh word to any person in the entire universe. Yes, that's correct. So it is my distinct honor to present to you my dearly beloved Justice Flerida Ruth Pineda Romero.
Now I've got my props. Can I already pour? Oo, sige. Oo. Thank you. So dapat came prepared from. Oo. Don't be scared.
No recitation.
No recitation, says another former student. I'm very sorry. Just took about a few minutes of your time. Thank you very much, Dean Danny Concepcion. Thank you, Professor Dawai. Where are you? There it was covered by this one. Thank you so much for your kind words. I'm so overwhelmed. I thought Pats would never end. That's really the first part of my lecture, you know? So it's good. I don't have to go through the first part of the lecture. I must have given them a grade of 1. Really, because they were both my students, as they told you. And I see a lot of my other students here. So I want to address all of you, Dean Danny Concepcion, of course, and your wife is not even here, but I address her because I know she's often by your side also. Dean Danny, and I see another Dean. Dean Raul. Pangalangan? Oh, at the back. As usual. I hope I didn't miss any other deans, the faculty members of this College of Law, the students, my former students, members of the Willow Sea, members of the Portia sorority who gave me these lovely flowers. Thank you so much. And my friends, the guests who are here. I really don't know how to thank you for coming here, even if probably you already know what I'm going to say. But anyhow, I am going to, this I'd like to tell you first. In public speaking, there's a cardinal principle. Don't start with an apology. But I'm going to violate it with impunity. I would like to start by apologizing right away because I see before me now lawyers, law students, former students, members of the faculty, law practitioners. But I also see non-lawyers, my friends, and others. And so I apologize right away, first to the lawyers. the lawyers. Let me say this. I look around and I see that there are several non-lawyers. And so, pardon me, attorneys, deans, professors, etc., pardon me if I go into the basics sometimes, the elementary principles of what some of you are studying right now or have studied, persons and family relations. Because otherwise, my friends, those who are not lawyers, may be clueless about what I'm going to say unless I give a brief introduction to those aspects of my subject. And then on the other hand, will you please, I beg your indulgence if, on the other hand, there are certain parts of my lecture, like the decisions of the Supreme Court, etc., where I will not introduce concepts of law anymore, but I'll just plunge into that subject right away. So I apologize to the non-lawyers, and I apologize to the lawyers also. We'll try to effect some kind of a balance. I know that somebody here just told me, oh, makikinig ako dito sa lecture mo. Sabi ko, salamat naman. Because, sabi niya, yung ibang lectures, and I have received invitations, hindi ako pumupunta. Dahil hindi ko masyadong maintindihan. And inside myself, I said, ako rin eh. Well, and she continued to say, you know, I have been invited to these Centennial lectures. But from the title alone, I cannot understand some terms. One is laicity. I don't know what that means, she said. Then there's another one, meta-narratives. That's another one. And she said, I took literature, but I don't understand that. And inside me again, I said, neither do I. But actually what I told her is, well, you know, I know what you're referring to. The lecturers for those subjects were deans, and deans are a special lot. They're a special group. They're up there in the legal stratosphere. They speak a language of their own that we ordinary mortals don't understand. So don't worry, I said. Anyhow, she said, I came because I'm familiar with your subject. I have a family. I have, what else? I have children. I have a husband, etc. Okay, good. So with that, I would like to start my lecture. Some of you must be familiar with the family of man. Are you? That's the most successful photographic exhibition ever assembled, consisting of 508 photographs depicting the universality of human experience with vivid shots of birth, love, and joy, as well as war, privation, illness, and death. Curated by Edward Steichen, it was first shown in 1955 at the Museum of Modern Art in New York. It traveled to 36 countries, and as of the last count, 9 million people had seen it. Was even turned into a book with introduction by Carl Sandburg, who happened to be Steichen's brother-in-law, and was added to UNESCO's Memory of the World Register. Evidently, this is a piece with the Universal Declaration of Human Rights, which asserts in the very opening paragraph of its preamble, whereas recognition of the inherent dignity and of the equal inalienable rights of the members of the human family is the foundation of freedom, justice, and peace in the world. To be sure, this is but to emphasize the links that bind members of the family of man, such that the fate of one is the fate of all, idealized in universal brotherhood. At the micro level, because I consider that as the macro. At the micro level, however, we are more concerned with not so much the family of man as the family of a man. For no one is without a family except probably Adam and Eve that eventually produced the family of man. In our case, we are begotten of a family, and in turn, we beget a family, or in the case of our macho men, several families. So recognize since time beyond mind, in lore and legend, in prose and poetry as the bedrock of civilization, we have not let pass any opportunity to extol the place of the family in our society. In full accord with the policy statement of the Universal Declaration of Human Rights that says the family is a natural and fundamental group unit of society and is entitled to protection by society and the state, the Constitution of the Philippines likewise incorporates in its state policy, says the state recognizes the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. And then it goes, our Constitution, you're familiar with it, most of you, goes further by adding one whole article, Article 15, with 4 paragraphs devoted to the family. I remember that it is to Justice Cecilia Muñoz Palma that she was the president of the 1986 Constitutional Commission, that we owe this dominant position of the family in our 1987 Constitution. From the very inception of the Constitutional Commission, she made known to all the members her magnificent obsession to have a whole article on the family, and she went lobbying to all the members, her colleagues. I recall very vividly the time when she was up there being president of the CONCOM. She came down, she had her authority and power to speak from the floor for her favorite, advocacy, and to clinch the commitment of her colleagues. She went to the ladies there, including myself, one by one, and she said, if they do not put this article in the Constitution, let's all walk out. Can you imagine Justice Cecilia Muñoz Palma advocating, Attorney Nelly and Justice Mini advocating that we all walk out? And so, maybe intimidated, her colleagues passed, and we have Article 15 of the Constitution. In this context, it is not difficult to understand why there is such a hue and cry over the controversial RH bill, now pending in the halls of Congress. Perceived by some as a population measure, it is seen by others, including theologians, as a travesty on the handiwork of God. As of now, as you know, it is Sisyphus-like, undergoing an excruciating ascent, and in the process is generating more heat than light. And understandably, every Juan, Pablo, and Jose insists on contributing his 1 peso worth of opinion to any move that would seem to undermine the family. At this juncture, I would like to give some kind of a flashback, historical background, probably briefly, because you will hear me talk about the family code. That's the law at present, but it only took effect as of April 3rd, 1988, family code. Before that, it was Spanish Civil Code in 1889, Spanish Civil Code. And then it was amended in 1950 by the Civil Code Revision Group in 1950. We then called it new civil code. So, if I refer to the present law, meaning the family code, and then I'll say the previous law, that's the civil code of 1950. But even before that, the Spanish civil code, because there are vestiges of that Spanish civil code in the present law. I would like to skip parts of it, because even in their younger days, I know some in your younger days, I know you never liked history. But there was a time when I would hear professors, our professors, talking about the Spanish civil code, etc. And I started wondering, what about the pre-colonial times? Is it all a tabula rasa? I never heard. Was there a law? Was there a legal system at that time? Oh, yes. In fact, our indigenous people, from the going to the agricultural stage, when we had barangays, 30 to 100 families in a barangay, they already had more lax standards of morality. During pre-colonial times, they had already polygamy, they had divorce of a sort, and rather liberal divorce or separation on grounds of incompatibility, neglect, or misconduct. And down south, I'm still talking of pre-colonial times, already there were Muslims in the coastal regions of Mindanao, and they had brought with them the Sharia, which is for them not just a law, but a code of life. And marriage was a religious institution. Now, the concept of separation of church and state was unknown. So even as early as the pre-colonial times, we already had a unification of church and state. Now, when these Spaniards conquered the Philippines, as you know, they came with a sword in one hand and the cross on the other hand. And that is why we saw the pervasive influence of the church. And at its core was the early Roman law and also the Code Napoleon, both in practically one breath. And in this Spanish civil code, we see the seeds of the legal concepts which so debased the female sex that some 60 years later, our government decided to obliterate the concepts of patria potestas, where the authority was the highest living ascendant in the family, and also where the women were always under perpetual tutelage, first under the father, and when she got married, under the husband. At this juncture, I resist the attempt to lead you on a fascinating journey to the Spanish times. I would just like to refer you to very good books written by our own law professors here. The Civil Code Reader of Professor Carmelo Sison in 1955. Very good compilation of articles. And then the recently launched Centennial book by Dean Agabin, Mestizo, the Philippine Legal System. And I want to make mention of that very informative article, the Spanish antecedents of the Civil Code by Professor Balani. So I will not go into that. There, I suppose there are copies in the library. So I've told you I told you of the Spanish Civil Code, and then this was interrupted by the American marriage law, and then by the divorce law, 2710. That was in 1917. There was absolute divorce during that period. But in 1950, when the Civil Code was revised, no absolute divorce anymore. The implication of all this is that we, the conquered people, have had to adapt ourselves to the mores, the cultures, and traditions of our conquerors. Happily, in 1947, after the World War, President Manuel Rojas convened this Code Commission, headed by Dr. Jorge Bocobo, Dean of the UP College of Law and later President of the UP. And because at that time, there was a need for revising the Spanish Civil Code and to make it conform with the customs, traditions, and idiosyncrasies of the Filipino people. So finally, it took effect as Republic Act 386. But you know, 57% of the 2,270 articles were still derived from the Spanish Civil Code. Then, I go to the next major effort to introduce radical amendments to strengthen the family and clearly define the rights of women in our society. Also to provide additional safeguards for the protection of children and bring our law on paternity and filiation in step with the latest scientific discoveries. So the Civil Code Revision Project under the UP Law Center was launched in 1979. As director of the UP Law Center, I was privileged to be designated chair of this committee that was tasked to prepare a draft of the revised Chapter 1 of the Civil Code. This we did jointly with the IBP. But when the resources of the IBP ran low, the Law Center took over completely. And under the chairmanship of the renowned civilist, Justice J.B.L. Reyes, with co-chairman, Justice Ricardo Puno. There was really a need to revise this Book 1 of the Civil Code. And so for 7 years and 8 months, we did work right there in that Bocobo Hall. When the formidable task was finished, it was signed into law as Executive Order number 209 in 1987 by President Corazon Aquino, as in her capacity as legislator. The resultant Family Code, enacted separately from the Civil Code, took effect on August 3, 1988. Now, marriage has always occupied a predominant part in our law, the way the family does also. You know that marriage has undergone a different definition. In our family code, it is now defined as a special contract, not just an ordinary contract, special contract of permanent union, not just union, but permanent, entered into in accordance with law for the establishment of conjugal and family life. It has to be permanent because under the influence of the Catholics, what God hath put together, let no man put asunder. And marriage has always been regarded as an inviolate institution, even if there is no lack of skeptics like Zaza Gabor, who will be remembered as having quipped, "A man in love is incomplete until he gets married, then he's finished." That's Zaza Gabor, supposed to be an expert in these matters. Or Helen Rowland, who said, "Love is the quest, marriage the conquest, and divorce the inquest." So, when the Code Commission of 1950 was faced with the proposal to restore and legalize absolute divorce, it was turned down by the members. Even under the present civil code, our family code, there is no absolute divorce. No matter that some witty legal scholars claim that there is indeed a remedy available through the side door. But more of that later. Now, we gave the definition of marriage. Who are the partners in marriage? Of course, a man and a woman, we say. In fact, we see that in the family code, it says legal capacity of the contracting parties, who must be a man and a woman. In the past, the codifiers felt there was no need to include this man and woman phrase. I remember when we were in the throes of revising this civil code, and somebody suggested, let's include man and woman. And his suggestion was met with an outburst of laughter. What's the need? We take that for granted. But he said, no, but you never can tell, ... And true enough, his words were prophetic. It's good we now have man and woman, isn't it? To an increasing extent. Now, national laws, state laws are enacting legislation legalizing same-sex marriages. You know what I mean? Last June, it was legalized in New York under the New York state law. There is even a Filipino male who got married to an American male in New York. But soon after, Archbishop Dolan issued an official statement declaring that no Catholic facility or property, including but not limited to parishes, missions, chapels, meeting halls, it's a long enumeration, and even items dedicated, consecrated, or used for the celebration of Catholic liturgy, none of the above, as we might say, may not be used for the holding of consecration of same-sex marriages. None of this, that's in New York, that's what Archbishop Dolan said. And he reaffirmed the intimate partnership of life and love that constitutes the marriage state was established by God and endowed by Him with its own proper nature and laws. Consequently, the Church has the authority and serious obligation to affirm the authentic teaching on marriage and to preserve and foster the supremely sacred value of the married state. Conservative elders, and that includes, I'm sure, some of you here, now shake their heads in disbelief, saying, I never thought I'd live to see the day, etc., etc. And children are suddenly thrust into a bizarre situation, not forewarned, and not unannounced, and unannounced. Their families are now transformed from being dad, mom, and the kids into two dads or two moms and the bewildered kids. Imagine the legal problems that this unusual kind of familial arrangements pose. Nowhere is this mentioned in the books, and so it comes as a rude shock when property has to be settled upon the death of one of these parties, same-sex, or death benefits have to be bestowed by the employers to the lawful heirs. I understand that some textbooks are now in the midst of being revised to redefine the family or the definition of family to include two men or two women as parents. A friend of mine called me up simply to blurt out her feelings, and she bewailed, can't you see how our society will get into this sooner than later? But I calmed her down and said, don't worry, don't worry. This was anticipated by the codifiers, those who revised the civil code, etc. And as we told you, a requisite for a valid marriage is that it be a permanent union between a man and a woman. So if you're still wondering, are we going to get to that point soon? At least not while the law says so, that it is a permanent union between a man and a woman. But suppose, my friends asked, in a last-ditch attempt to evade the law, one decides to undergo surgery for a sex change. How's that? Surgery. The Supreme Court was once confronted with such a dilemma. When is a man a man? And when is a woman a woman? Does the law recognize the changes made by a physician using scalpel, drugs, or hormonal treatments? May a person successfully, this is the issue before the court now, may a person successfully petition for a change of name and sex appearing in the birth certificate to reflect the result of a sex reassignment surgery. That was the issue in this case. What was the case? Romel Jacinto Dante Silverio versus Republic of the Philippines. In turning down this petition for a change of name after successfully undergoing surgery in Bangkok, because he said he was anatomically male, but feels, thinks, and acts like a female. Poor guy, poor gal. The Supreme Court declared that it cannot be argued that the term sex was used in the Civil Register law, which was enacted in the early 1990s, is something alterable through surgery, or something that allows a post-operative male-to-female transsexual to be included in the category female. The court said, considering that there is no law recognizing sex reassignment, the determination of a person's sex made at the time of his or her birth, if not attended by error, is immutable. Immutable. The changes sought by the petitioner will have serious and wide-ranging legal and public policy consequences. So the Supreme Court, until now, has yet to solve its dilemma. When is a man a man? And when is a woman a woman? In this case, the decision not to recognize the sex change as valid was limited only to the petition for a change of name. Nowhere on the horizon of family law is there a definitive ruling on the effects of such surgery or hormonal treatments. Do they merely result in a cosmetic change? Or do they bestow reproductive powers upon the transformed woman? You answer that. I don't know. Now, proxy marriages. Do we have proxy marriages? In other jurisdictions, proxy marriages are allowed where there can be a stand-in for an absent contracting parties, especially during wartime. Under the family code, however, one of the essential requisites of a valid marriage is consent freely given in the presence of the solemnizing officer. Not only that, the contracting parties must appear personally before the solemnizing officer. Clearly, marriage cannot be contracted by proxy nowadays or in absentia of one of the contracting parties. However, under the marriage law, upon the arrival here of the Americans, proxy marriages were allowed under the marriage law. I will not cite anymore. I will not cite, or I will, whatever is, they're all in this article of mine. And then, in connection with the ceremony to be performed, it says that under that marriage law, the person authorized by special power of attorney to represent the absentee shall appear. But these proxy marriages in the States, in California, for instance, are recognized. And they frequently pose conflict of laws issues. For example, California, I mentioned, because many military servicemen were deployed to Afghanistan and Iraq conflict zones, the state of California allowed proxy marriages. In case the man dies in the war zone, the wife whom he married by proxy would receive the benefits accruing to her by law. A Filipina went to California under a fiancé visa and married a U.S. military serviceman based in Afghanistan via a proxy marriage. Now, how would such a marriage be characterized under our laws? Under the lex loci celebrationis doctrine, a marriage valid where contracted is valid everywhere. Does that mean, therefore, that said proxy marriage is valid in the Philippines and binding on that Filipina? But Philippine laws pertaining to status, legal capacity, condition of persons are binding upon Filipino citizens even if they are living abroad, as we know. So, there is a bind again, a dilemma. And yet, to an increasing extent, similar problems arise as a result of mixed marriages, thereby raising conflict of laws issues. Now, how about common law marriages? You know common law marriages. They're very common about classes D and E, and let's say spouses who separate legally or not, maybe separation for a fact. De facto, they separate, they fall in love with other men or women, and they live together, cohabit. No ceremony, no marriage. These are common law marriages, it's called. But this informal arrangement is not recognized and valid under our jurisdiction, where one of the essential requisites of a valid marriage is consent freely given in the presence of the solemnizing officer. And a formal requisite is a marriage ceremony. Isn't that right? There is no marriage ceremony here. But look at the concern of the state in trying to validate the marriage, make it formally legal in this in this family code. Now, if a man and a woman have lived together for at least 5 years without benefit of marriage, if they decide to get married and there is no legal impediment, they can get married and they need not procure a marriage license. So in that way, this legalized concubinage, it is legalized now, and the parties enter into a valid marriage. Henceforth, the children are legitimate. So you see how our state really shows concern for such marriages. Merely cohabiting together, therefore, is not valid in the Philippines. Then, I will show you that the law has sought to strengthen and stabilize the institution of marriage from its commencement by one way by which they have done it is to change the marriageable ages of men and women who enter into marriage, as long as they must have the capacity to procreate. They must have the maturity of judgment and discretion and be able to support the family. That's why the age was made variable. Under the Spanish Civil Code, the female should be 12, and the male 14 to get married. Totoo yan. That is Spanish Civil Code. And then the Civil Code of 1950, the female should now be 14 and the male 16. Now, under our family code, students of persons in family relations, what's the marriageable age now? 18, aba? Uno dapat ibigay sa inyo. Who's your professor? I will tell Professor Beth Pangalangan and Katrina Ligharda, who wanted to be here but is in Pangasinan, to give you a 1. Because you know now, under the family code, men and women, in order to effect a valid marriage, must be 18, uniform. At last, the women have caught up with the men. Isn't it so? That's one of the radical innovations. Now we are on par with the males. But before, they looked down on us, implying that emotionally and mentally we are inferior to the men. But look at this. 18 is the valid age for contracting a marriage now. And under an amendment, 18 is also age of emancipation. So, you get married when you're age 18, you're already emancipated, not because of getting married, but because 18 is the age, new age of emancipation. And yet, if you're 18, between 18 and 21, you need the consent of your parents. But you're already emancipated. Don't you see that? So those of you who will be revising the law in the future, there are many spots in our laws that need amendment. So already 18, but not yet 21, you still need to get the consent of your parents. But you're already 18, emancipated, and that means you are legally capacitated to enter into any kind of civil act. And age 21 to 25, you still need the advice. Look at that. Well, I don't know. But there's a need for amending. Now, it's so clear that one of the grounds for annulling a marriage is that the contracting parties did not secure the consent of their parents when they were ages from 18 to 21. That is a ground for annulling the marriage, a ground already existing at the time of contracting the marriage. So, another instance that I'll tell you, one of the strongest presumptions in law is the validity of a marriage once contracted with the essential and informal requisites. You know, there are essential requisites: legal capacity of the man and the woman, legal capacity, the age. These are essential, absent which the marriage will be declared void. But there are not so essential, formal, pertaining to the form. And this may just make the marriages not void, not annullable, but irregular. Now, there is, before, by the way, under the Spanish Civil Code, a marriage contracted in good faith produces civil effects in good faith. So that even if the marriage is declared void, later it will produce civil effects. And good faith is presumed if the contrary is not shown. But in the Civil Code of 1950, they were stricter. And good faith is immaterial. By good faith, I mean the good faith of the contracting parties. As regards the solemnizing officer, the authority of the solemnizing officer was made an absolute condition for the validity of a marriage that was in the Civil Code. Now, under the Family Code, the good faith of one or both of the contracting parties saves such a putative marriage from being void. So we consider now the good faith, unlike before. Now, for the liberalizing trends affecting marriage, it has been said often enough that marriages are not made in heaven, at least not all marriages. For all individuals have their idiosyncrasies, their foibles, their peculiarities, which may not be all that visible or evident at the courtship stage, but may manifest full-blown after marriage due to the stresses and strains of responsibilities unforeseen. Now, these idiosyncrasies may surface even before what is called the 7-year itch. So, what should the couple do? Should they buckle down to these pressures of a marriage that has turned sour But the state, on the other hand, it is to the interest of the state to preserve inviolate a marriage to protect this fundamental institution which is the cornerstone of society. But are not the individuals entitled to happiness and the freedom to procreate as their basic human right? There you are. So the state, through the official guardians of our morals, stability and harmony of the home and family, finds itself endlessly impaled between the twin horns of this dilemma. And state policies have tried to resolve this seemingly endless problem by putting down different options. As I told you earlier, even before the Spanish times, the people observed rather lax moral standards with polygamy, with divorce. But when the Spaniards landed on our shores, bringing with them the stringent moral standards of the Catholic Church, which prevailed over the legal system of the natives, in quotes, the era of the unity between the state and the church commenced. This included the ban on absolute divorce, because the union of a man and a woman was a sacrament to be sedulously protected and upheld. For what God has put together, let no man put asunder. Now, with the advent of the American regime, that Act 2710 in 1917, I told you, divorce, absolute divorce, that will really cut the ties of marriage, was recognized and regarded as a liberalization of the laws regulating family relations. But when the Civil Code was revised in 1950 and became Republic Act 386, the framers opted to abolish that absolute divorce. Instead, the new Civil Code introduced relative divorce, a mensa et thoro, from bed and board, on certain grounds only. Actually, two very limited grounds: adultery on the part of the woman and concubinage on the part of the husband, as well as an attempt to take the life of the other. Only on those grounds would legal separation be granted by the courts. Only on those two grounds. And yet, the marriage ties were not severed. You're only separated, you don't live together, but you're still married to each other. So you cannot get married to some other people. Is that right? So, but with the promulgation of the Family Code, I tell you, it is liberalizing. These are the trends in marriage. They opened wide the door for legal separation. They took that ground attempt to take the life of the other, but they expanded the grounds for going to court to seek legal separation. Never mind if it did not cut the marital bonds. At least you're separated. Like what grounds? You'll be surprised. Physical violence, a final judgment of imprisonment on the part of one of the spouses, lesbianism, homosexuality, bigamy, sexual infidelity, or perversion, abandonment. These are grounds for legal separation. You see, there are many more grounds now. Why? Because of the changing mores, the increased industrialization of our society, increased modernization, that are now exerting so much pressure on our young people. One phenomenon in our society is the proliferation of call centers in our major cities, and statistics will show that our country has surpassed India. You read that, didn't you? Very recently, there are more call centers here now. What is abhorrent is that these young professionals who have been assigned to night shifts suffer physically and emotionally, and worse, have evolved their own moral standards, lax moral standards. Quirky and perverse ways of life have come out in the open. The influence of the elders on the present generation has waned as more young people leave their sheltered homes and live solo or with partners of questionable gender. I don't know, some of you here may be working in call centers. So now, under the civil code, because absolute divorce continues to be prohibited, there is a kind of a loophole. I don't know if you will consider this as a loophole. But what the members of our Civil Code Revision Committee did in an attempt at liberalizing the grounds for terminating a marriage, terminating, really cutting the marital bonds. They, well, I'm guilty of this too, being part of the committee, took a leaf from the canon law of the Catholic Church. Parenthetically, this is not to say that the annulment granted by the matrimonial tribunals of Rome would automatically be recognized here. No, that is not what this kind of divorce means. Now, the revision committee decided to adopt paragraph 3 of the Code of Canon Law because the Philippines was and still is a predominantly Catholic country. At least this is a socially acceptable option. Better than absolute divorce. That's what they're saying. And so those who desired to break their marriage bonds without unduly doing violence to their religious scruples said, at last, we have divorce. Now, that is what one of my friends did. Well, but I'll tell you first, what does this mean? We often read in the society pages, we do have society pages, that showbiz personalities and public figures are often quoted, these big-time actresses and actors. The moment our annulment decree is handed down by the court, I will be free to marry so-and-so, her current boyfriend. The same with the other sexes. We will now be freed from each other as soon as the annulment decree is handed down. That is the trouble. Unknowingly, they are using the term annul incorrectly. It's not so. It's not annulment. Marriage is considered annullable or voidable due to certain grounds existing at the time of the marriage. And then, if granted this annulment decree, it will, of course, void the marriage. But while there is no annulment decree, the marriage is valid. It is valid until annulled. And it's not also a divorce. Again, because divorce is to be given under certain specified grounds. In other countries, as you said earlier, it seems like the Philippines is the only holdout now, a Catholic country that still does not recognize divorce. But divorce should be for grounds that will exist after the marriage. When they say, oh, we are now incompatible, we don't understand each other, he does not come home, he does not have a job, such and such. But you'll be surprised. Because this is not divorce either. This novel way of terminating a marriage indicated in the new Article 36 is based only on one ground: psychological incapacity to comply with the essential marital obligations of marriage of one of the contracting parties existing at the time of the celebration of the marriage. And the liberating court order is not annulment, but what we call in law a declaration of nullity, which is not synonymous with annulment or with divorce. And the essential marital obligations of marriage are to live together, to observe love, respect, fidelity, and give each other mutual help and support. I'll read to you, because it's important, Article 36 on psychological incapacity. A marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void even if such incapacity becomes manifest only after its solemnization. You can see from that definition that the revision committee studiously skirted a real definition of psychological incapacity. It even avoided giving examples that could serve as templates for the judges who would bear the onerous burden of having to exercise wide discretion and latitude in resolving cases under this novel provision, even as these judges gingerly tread the unfamiliar terrain of psychological disorders. Why? To have given specific cases would have limited the applicability of said provision under the principle of, and I now go to the technical term loved by lawyers and teachers and judges, eius dem generis, which is a canon of construction that when a general word or phrase follows a list of specifics, the general word or phrase will be interpreted along the same line as the specific ones. But to my mind, the more cogent reason why the committee did not give specific instances of psychological incapacity is that it may be interpreted like this. You mentioned this, therefore, those that you do not mention are excluded. These are the only grounds. And what do we call it? Inclusio unius est exclusio alterius. To avoid that. Obviously, it was the intention to have the judge decide each case before him on a case-to-case basis with resilience. Applying what? Experience. The findings of experts in psychological disciplines, and by decisions of church tribunals. After all, we took this from the canon law of the church. So that in one case, it said that the definition of psychological incapacity was not cast in intractable specifics. Judicial understanding of psychological incapacity may be informed by evolving standards, taking into account the particulars of each case, current trends in psychological matters, and even canonical thought and experience. An acquaintance of mine was so happy when she learned that this Article 36 was at last enacted into law. So, dancing the Indian war dance, she whooped, "At last I can get rid of my husband, this beast." It's better said in English than in the vernacular. This is the misimpression of so many other wives who have suffered in silence the indignities of their brute of a husband. So this lady, when I explained to her, no, wait, oh, she would not even listen to me. Basta! I can get a divorce now from him. And no matter how I tried to placate her or whatever, I just stopped. It was useless. I'll wait until the euphoria has subsided, I told myself. So you see, this is not divorce, although it will cut the marital bonds. And as the office of the Solicitor General once said, tongue in cheek, they called this Article 36, it is the most liberal divorce procedure in the world, coming from the Solicitor General, and they called it procedure. But you see, the only ground for psychological incapacity is that the spouse cannot comply with the essential marital obligations of marriage. And that incapacity should have been already existing at the time of the celebration of the marriage, even if it manifests afterwards. Well, again, a more perceptive and sober lady told me, if this is supposed to be present at the time I got married to him, I would not have married him. Hindi pa sana ako nagkaroon ng sakit ng ulo. That's what she said. Siya nga naman, ano. But definitely, our laws still do not recognize absolute divorce. Here is a way out. That's what they say. Under Article 36, psychological incapacity. And so you see the looming crucial question for every judge before whom you bring a case like this is, does this act or these acts complained of constitute psychological incapacity? So with no law to guide him, because there is none, in Article 36, he is constrained to make his own law, to turn to decisions already rendered by his own colleagues, or maybe decisions of similar cases in other jurisdictions. But absent such guidelines, he has no choice but to strike out on his own with the invaluable scientific assistance of psychiatric experts. Now, because thousands of married couples trapped in their marriages had been waiting for such a rare opportunity to end their marriage, many walked through this wide open, inviting door, and a Pandora box was opened. Jurisprudence started evolving case after case. With each pronouncement, to be sure the judges knew better than to declare any psychological psychosis or disorder actionable. But I can tell you, I can give from all these thousands of cases, here are some instances where these are not considered psychological incapacity. Like your husband is philandering, you think that will fall under psychological incapacity? No. Or sexual perversion. You see him in your bed with another partner, worse, with a partner of the same sex. Or habitual alcoholism, abandonment, non-cohabitation, immaturity, irreconcilable differences on such matters as discipline of the children, finances, relationships vis-a-vis the in-laws, even emotional maturity and irresponsibility or refusal to look for a job. What are all these? Ad infinitum. They are not instances of psychological incapacity. So for those of you who are saying, now, here is a way by which we can end our marriage. Even alcoholism, even refusal to look for a job, or immaturity that you are only discovering now. So, if these are not cases for psychological incapacity, what are? Here, inveterate pathological liar. Manifestations of psychopathic personality. What does that mean? Infliction of physical violence. Some cases of physical violence may constitute psychological incapacity. Other instances of physical violence, no. But these are grounds for legal separation, as I said earlier. Still more grounds for psychological incapacity, drug addiction, psychosexual anomaly, and others that are grist for the judicial meals. So, judges, and I see several of them here, the judges, it is up to you now to interpret Article 36. At least there is now a body of jurisprudence, of case law on this article. And it is case after case after case that is building up this body of case law. And I shall make the task of the law students here easier by kind of summing up. There are several cases, each one adding to this growing body of jurisprudence regarding psychological incapacity. And I'll try to cut it. Santos case on Article 36, it said that there is hardly any doubt that the intendment of the law has been to confine the meaning of psychological incapacity to the most serious cases of personality disorders, clearly demonstrative of an utter insensitivity or inability to give meaning and significance to the marriage. And it should not be physical incapacity, but mental. And it mentions characteristics like gravity, juridical antecedents, and incurability. It's here. I will not read them anymore. Then Santos' case was followed by the much-quoted Republic of the Philippines, Republic versus Court of Appeals and Molina. And you'll hear this being cited, Molina, because it gave 8 guidelines, which I'm sure you have all memorized in your classes, no? 8 guidelines in Molina. I will not give most of it. That has already been taken up. But there is one sore point. And the practicing lawyers were very happy when this was obliterated. What? One of the guidelines says no decision shall be handed down unless the Solicitor General issues a certification which shall be quoted in the decision, briefly stating therein his reasons for his agreement or opposition, as the case may be, to the petition. So this role of the Solicitor General raised so much hue and cry among legal practitioners because it was foreseen that it would cause much delay. And true enough, it did. And not only that, but it will give an opportunity for underhanded practices, even leading to corruption. And that this intervention was actually superfluous because the prosecuting attorney or the fiscal were required to appear as counsel on behalf of the state to ward off any collusion between and among the parties or to take care that the evidence is not fabricated, so that recognizing the merits of the clamor of the practitioners, Administrative Matter Number 02-1110, which dispensed with the certification of the Solgen, which was required in the Molina case, caused a lot of joyous celebrations among the law practitioners. Then, a later case, Marcos versus Marcos, clarified there is no more requirement that the defendant or respondent's spouse should be personally examined. No more requirement as a condition sine qua non. So, there is no need to assert that in the petition. But the psychological incapacity must be established by the totality of the evidence presented during the trial. In no kind of case are facts more important than in this psychological incapacity case, because you will have to prove through evidence. Then the case of Ngote versus Yute, where the Supreme Court or the justice dispassionately criticized even the case of Molina. It says that the resiliency with which the concept should be applied and the case-to-case basis by which the provision should be interpreted as intended by the framers had somehow been rendered ineffectual by the imposition of standards, very strict standards, by the Molina case. And the court said, Molina case has become a straitjacket, forcing all sizes to fit into and be bound by it. Wittingly or unwittingly, the court has allowed diagnosed sociopaths, schizophrenics, nymphomaniacs, narcissists, and the like to continuously debase and pervert the sanctity of marriage. But a cautionary note, though, lest we go overboard in junking the Molina decision, no. The court said, we simply declare that there is a need to emphasize other perspectives. I'll skip those. And now there is a suggestion by the court to include in the rules. There are always rules to regulate these proceedings. Include this is the suggestion of the court, an option for the trial judge to refer the case to a court-appointed psychologist or expert for an independent assessment and evaluation of the psychological state of the parties. But this rule does not dispense with the parties' prerogative to present their own expert witnesses. And then a further relaxation of the stringent rule in the Molina case is found in the Suazo case. It stated that the requirement in the Molina case for the petitioner to allege the particular root cause of the psychological incapacity has proved to be too expensive for the parties, thus adversely affecting their access to justice of poor litigants. And besides, there are provinces where there are no psychologists. What do you do with them? The expenses, if you must know, incident to applying for a declaration of nullity under this Article 36 is staggering. One judge who's here estimated it to range from 100,000 pesos to millions. The money goes to the attorney, 50,000, to the psychiatrist, 30,000 plus traveling expenses, and allegedly another 50,000 or 100,000 for the judge, as well as another amount for the prosecutor, solicitor. I'm looking at the judges here, but I don't think they do that because they were my former students. So that takes care of that. Those of you who want to really earn money, you might as well specialize in these psychological incapacity cases. But as I told you now, to go to another topic, divorce has never been a way out, the way it's really technically defined. But this same effect is achieved indirectly, what I would call an indirect kind of a divorce. You may not know, but that is what it is. Because the result, the effect, is also a cutting of the ties. Article 26, second paragraph. When there is a marriage between a Filipino citizen, usually it's the woman, the wife, there's a marriage between the Filipino citizen and an alien spouse, and this foreigner spouse later goes abroad and validly gets a divorce, that is by the alien spouse, that capacitates him to get married. The Filipino spouse, the woman, the Filipina, shall likewise have the capacity to remarry under Philippine law. So without lifting a finger, this alien spouse of hers goes abroad, gets a divorce, which capacitates him to remarry. Why? What happens to this woman, this Filipina left behind? She's now allowed also to remarry. Otherwise, it will only produce injustice. Isn't it unfair to the Filipina who's left behind? She is here married to a man who's no longer married to her. What a ludicrous spectacle. And the citizenship of that alien spouse, by the way, it should be his citizenship at the time he applied for a divorce. And by that time, he may have been a naturalized citizen. So that is what I call indirect divorce. Now, I go to paternity and filiation. I will not quote here. I have quotations. Universal Declaration of Human Rights states this as a policy underscored by our Constitution again, foundation of the nation, etc., etc. I'll skip all of these. But, you know, it is to the interest of the state to uphold the legitimacy of children because this status spawns their legitimate rights. Like what? To bear the name, surname of the mother and the father. To get support. And also, to be entitled to the legitimate rights of succession. But while we have our family, nuclear family, the parents and the children, you know that the Filipino family is much bigger. You have the clan, you have the relatives. These tentacles are not considered family, although they claim to have the rights. Now, under the civil code before, there were different kinds of children. You have legitimate children, you have illegitimate children, but under legitimate children, you have the natural children. The natural children by legal fiction, you have acknowledged natural, and on, ad nauseum. But now, we have in the family code only legitimate and illegitimate children. That makes it easier for the law students now, depending on whether these children were conceived and or born during wedlock. Now, if there is a discernible trend in law to uphold the legitimacy of children, there is also a discernible trend to improve the status of illegitimate children. If you don't know it yet, Senator Ramon Revilla Sr. in 2004 sponsored a law, and it was passed into Law Republic Act 9255, where illegitimate children, if expressly acknowledged by their fathers, may use his surname, not merely that of his mother. How? Expressly recognizing through the record of birth appearing in the civil register, or when an admission in a public document or private handwritten instrument is made by the father. And of course, such recognition will expectedly pave the way for support. And the support can be what? 150,000 or 1 million in a month's time to be distributed among the, how many? 88 children or 80 children whom a macho male might sire. Now, let's go on now. The gigantic strides, The gigantic strides made by science and high-tech have made possible the manipulation of the procreative process in a manner that has astounded people, opened up incredible possibilities to childless couples, and thrown the whole legal profession with its cherished presumptions pertaining to paternity and filiation all awry. To infertile and impotent couples, artificial insemination, AI, has come as a boon, as a surprise gift from the Lord probably, and has raised their hitherto unrealized dreams of having a child. There are different kinds of AI. There is, by AI, I mean when a woman is impregnated with semen from her husband or a third-party donor with or without the consent of the husband, without sexual intercourse. Depending on whose semen is used, AI may be AIH, H standing for husband. If it is the semen of the husband that is used, homologous, it's called homologous AI. Or it may be AID. This is not AIDS. AID. This is the AI using a donor's semen. That is heterologous AI. Or there's another one, AIC. What does C mean? Confused. That's true, huh? Confused or combined artificial insemination using the husband's and the donor's semen. And AIC, why? It is resorted to in order that the husband may still entertain a hope that it was his seed that successfully brought a child, no matter if the hope is illusory. First introduced in the 1940s, the cases of AI has grown by leaps and bounds and has raised so many vexing legal, ethical, moral questions. So, what to do with it? But there are some women, like lesbians, who are so happy about it. They can have children of their own. And also, even single women who, for their own reasons, would like to have children of their own without having to go to bed with another man. And they can even choose the man who will sire their child. That is why there is AI. One bachelorette. How do you say that? Bachelorette. Incredulous bachelorette told me, you mean we can now have children without having to have sex with a man, and I can choose the father of this child? Why? That's a virgin birth. That's one way of looking at it. But not unexpectedly, the theologians and the men of cloth, of course, object to what they describe as unnatural, unethical, and artificial way of having children. But you know, in our family code, which took effect 1988, as I told you, we had already anticipated this artificial insemination would bring in its wake so many perplexing problems. Because artificial insemination was introduced in the 1940s, and when we revised this civil code, made it into a family code, here is Article 164, which says, children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife, provided that both of them ratified or authorized such insemination in a written instrument executed and signed by them before the birth of the child. So, artificial insemination is recognized, this kind, if recognized and ratified by the parents. Now, all these well-loved presumptions of legitimacy in our, whether family code or civil code, they're practically thrown out of the window now. That much I can tell you. Because through the science of cryopreservation, married couples now can have children at their convenience. Parang junk food, it seems to me, the way I see it sometimes. Long, even anytime they want. You want a child to be born during the full moon, during the Chinese New Year, during Valentine's Day, you can do that. You time it whenever you want, as I said, at your convenience. Or even after the marriage has been terminated, even after the death of the husband. What's the secret? While the husband is alive, you freeze his semen. And then when you want the baby, you thaw the semen and go into artificial insemination. But this has brought about a lot of problems because it's often shrouded in secrecy and there are not enough laws to regulate it. Sometimes what happens is a wife may decide to unfreeze the semen of her living husband for purposes of AI, but without his consent. And that is his semen, you know. In such instances, there is the legal remedy of impugning the legitimacy of the child by the husband. This is what is called procreative autonomy, that you must know what is being done with what was part of you. You know? So, now, there have been donor centers abroad who claim that each donor can only be used for a certain number of times, X number of times. But who is to control and monitor actual distribution and use? How do you sanction a doctor who single-handedly, a doctor who specializes in this, who single-handedly provided this semen that impregnated all of these women that were going to his clinic? So that in that town, you knew that the children being born were more or less related to each other. What happens to incestuous marriages? What about the infamous fertility clinics where poor administration and mismanagement resulted in the mixing up of deposits? Consequently, it would result in the wrong assumption of parenthood of resulting offspring. So rampant has AI become that donations are now being exported and imported among countries. In the Philippines, it is the prohibitive cost that has prevented more infertile couples from availing of the medical procedure. Bizarre cases are brought to court to indict the doctors for negligence or medical malpractice, especially in the States. A white woman sued a fertility clinic and the sperm bank precisely for those illegal acts. Why? Because they mistakenly substituted another man's semen for that of her husband, both of them being white. And the child came out with African features. You can just imagine the chaos into which the family was thrown because of this. In another case, a man sued his ex-wife already, to prevent her from using or donating fertilized embryos, which they had frozen for later use. So again, there is procreational autonomy, the right to choose whether to have a child. In the U.S., very often, donors are recruited from medical students, residents, even doctors, because they're knowledgeable. They understand what it is all about. Of course, these donors prefer to remain synonymous because they will be saddled with burdens like, oh, this is your child, you support the child. And of course, the emotional toll being exacted on them. And do you know the practice of womb for rent? Okay. You're so young and yet you know this womb for rent, huh, Cindy? So, because if the couple cannot have children, they will have recourse to a surrogate mother. They can plant the egg, fertilized egg, into the womb of another woman because the wife cannot have anatomically a child. Oh, we know someone related to us. She asked her sister to be the womb for rent. Oh, and then after that, they got the baby. But there are some, these surrogate mothers, they become attached to the baby that is delivered. And they will say, this is my baby. Oh, what do you do in that case? Sure, I delivered that baby. O ngayon, kukunin ninyo sa akin. Oh my God. So there are endless and endless cases, problems spawned by AI. And we see this even in telenovela, especially when the baby born, knowing that he or she is the product of AI, he wants to know who are his biological parents, just like in adoption. And so they will go to such lengths to find out who's my mother, who's my father. Also for genetic reasons, they want to know, is there a predisposition to my having this kind of an illness, this or allergy? Yes. So there you are, telenovela. Now, bear with me, please. At least I'm keeping you entertained, huh? Now, we go, of course, legitimacy is really devoutedly to be wished for because of the rights accruing to legitimacy. But as I said, there are also rights that will accrue to an illegitimate child if you can prove that you are an illegitimate child, especially if you get an allowance of 1 million a month. No? Now, there are ways now, unlike before. The dean said something about trying to determine the filiation, paternity of a child through grouping. Not anymore. There is a more foolproof, scientific way of determining paternity and filiation. What is it? DNA. DNA. What is DNA? Oh, it's tongue twister. I hope you know it, but I'll try. Deoxyribonucleic acid. Anyhow, that's DNA. by now, law is starting to realize that it has neglected the potentiality of science coming to its aid. In the area of family relations, DNA is a very powerful tool for human identification because of its chemical stability, the uniqueness of the DNA profile of an individual, the identity of the DNA profile of any biological sample originating from one person, and the inheritability of DNA that makes possible the tracing of the relationship between parents and child or amongst kids. Besides, DNA is objective evidence that may not be influenced by psychological or social or emotional factors. DNA is the fundamental building block of a person's entire genetic makeup. Being a component of every cell in the human body, the DNA of an individual's blood is the very DNA in his or her skin cells, in her saliva, in the hair follicles, in the muscles, in the semen, swabs of other body parts. That is the same DNA you find everywhere in the body. DNA analysis is a procedure in which DNA extracted from a biological sample obtained from an individual is examined. Then this DNA is processed to generate a pattern or a DNA profile of the individual from whom the sample is taken. I have here in a paternity test the forensic scientist does this, and does that. I won't go into that. You will probably get a copy. Probably by email or whatever. Now, I'll skip that. So, there is a way of questioning paternity or filiation. In law, it is by impugning the legitimacy of a child. There are rules to that. Who can bring the action to impute? When can they bring it? Now, DNA helps a lot in this. You have the NBI and the PNB. They have DNA laboratories for the cases that fall under them. But right here, there is a DNA analysis laboratory of the Natural Sciences Research Institute. It's over there towards, I don't know, I have not been there. I think it's towards the Katipunan side. So, they will do these DNA tests for civil cases for a fee, of course. That is this laboratory. Now, I shall just go into the children in the clutches of the law. You have in the Universal Declaration of Rights, you have in 1924 the Geneva Declaration of Rights of a Child, but finally all culminating in the CRC, the Convention on the Rights of a Child, which the Philippines was so quick to ratify. So I'll skip all of those, and it's in our Constitution, by the way, so that finally we are committed to putting up a juvenile justice system in line with the CRC's, that's Convention on the Rights of the Child, CRC's doctrine of the best interests of the child. I have a long listing here, like just example, no? We have passed certain laws incorporating cherished principles like the child should not be labeled a criminal and thus be stigmatized for life. He is entitled to fair and humane treatment to attain the twofold end of juvenile justice, namely, the promotion of the well-being of the juvenile and the proportionate reaction by the justice system to the age of the offender. So against this backdrop, the Juvenile and Justice Welfare Act was passed. Now you know about the proliferation of crimes by the Batang Hamog and the Batas Kotse gang, the proliferation of these crimes, so that now there is a move in Congress to lower the age of criminal liability. Under our present law, it is 15, so that below 15, you will not be liable to answer before the courts. If you are brought there or even to the police precinct, they will just release you with impunity. Pretty soon you graduate in quotes, to being hardened criminals. So, what to do now? There's a debate going on there. Will amending the law by lowering the age of criminal liability solve the problem of increased incidence of crimes by these teenagers? Here is my take on this. As with many government programs, an increased budget allocation would go a long way in increasing the number of facilities and improving existing ones, as well as augmenting the salaries of social workers and other personnel. Then there should be planned and systematic training programs for the law enforcers on what subjects? On arrest, investigation, diversion, appearance in court, community involvement, and a change in attitude in handling the offenders. It would likewise help to put up more women and children's desks manned by skilled and sensitive police officers familiar with the applicable laws. The children's respect for the law and its enforcers will be enhanced with the latter's sympathetic interaction with them through sports and socio-civic programs. All these reforms need comprehensive planning and not merely on an ad hoc basis. My conclusion, yan, tapos na ako ha, isa na lang. Emerging trends in family laws brought about by modernization, increased urbanization, and the impact of high-tech devices render imperative our keeping abreast with global developments and being sensitive to shifting winds of change if we are not to be laggards in the family of nations. Thank you. Those who want to have copies, they will have. Dean, there's no more Dean.
I'd like to call now our reactors to the lecture of Ma'am Romero. I'd like to call first and introduce them individually. If you can take your seats, ma'am, and sir, in front. I'd like to first introduce our first lecturer will be the Honorable Rosalina Pizon, Vice Chair, Civil Law Department of the Philippine Judicial Academy. The Honorable Rosalina Pizon is a UP College of Law graduate, class of 1962. She began her career as a legal assistant and then as hearing officer of the Juvenile and Domestic Relations Court of Manila in 1966. She continued through 1977 when she resigned to engage in the private practice of law, which she did for 13 years until she was appointed in 1990 as Metropolitan Trial Court Judge of Manila. In 1964, she was promoted as Regional Trial Court Judge of Quezon City. Judge Pizon was awarded the Outstanding Judge Award from the City of Manila in 1991 and 1992, the Outstanding Metropolitan Trial Judge Award from the Foundation for Judicial Excellence in 1994, a recognition from the UP Women Lawyers Circle in 1994, and the Most Outstanding Regional Trial Court Judge Award of Quezon City from the Rotary Club in 2000. She also served as Vice President, Secretary, Treasurer of the International Association of Women's Judges, or the IAW, Treasurer of the Philippine Women's Judges Association, and as the country's International Liaison Officer of the IAW. In 2003, Judge Pizon was sent by the Philippine Judicial Academy and the National Jurist Institute to Vancouver, Canada to train on family mediation. She is a member of the Supreme Court's Committee on the Revision of Rules of Court, which is preparing the rules for family courts and judicial forms to be adopted by all of the family courts in the country. Judge Pizon was nominated and was finalist of the Outstanding Regional Trial Court Judge Award. She has been a member for several times of the screening committees, which was tasked to search for the Outstanding First Level Court Judge awardees. Judge Pizon went on to optional retirement in 2007. She has, however, been kept busy imparting her knowledge of the law by serving as a professorial lecturer of the Philippine Judicial Academy of the Supreme Court, the Institute of Judicial Administration of the University of the Philippines Law Center, and the Integrated Bar of the Philippines, as well as the Department of Justice and the Department of Social Welfare and Development. Our second reactor is Attorney Sedfrey M. Candelaria, who is currently Associate Dean for Student Affairs and Director for Admissions of the Ateneo de Manila Law School, the other school. He obtained his primary and secondary schooling at the Lourdes School of Mandaluyong, where he garnered a bronze medal in this, and all from grade school all the way to fourth-year high school. He has an undergraduate degree in political science at the Ateneo de Manila University in 1980, and in 1984 graduated from the Ateneo de Manila University School of Law and ranked among the top 20 of the graduating class. In 1986, Sedfrey left for graduate studies in law at the University of British Columbia in Vancouver, Canada, as a Rotary Foundation ambassadorial scholar, and was conferred the degree of Master of Law in the field of public international law. He assumed his post as Research Director of the Ateneo Human Rights Center, based at the law school in 1990, and became faculty of the Ateneo Law School, handling the Juris Doctor thesis program for 4 years and teaching street law as an elective course. He also teaches constitutional law, public international law, international economic law, children's rights law, refugee law, and the indigenous people rights. He also teaches business ethics and law at the Ateneo Graduate School of Business. So can we first begin with Judge Pison?
Ay, Diyos me. Ganito na lang po, mas madali. Okay, magandang hapon po sa inyong lahat. The usual greeting nowadays is magandang good afternoon. Magandang good afternoon daw. Just like Justice Romero, I would start my talk with an apology. Forgive me for wearing this red attire. Because you see, I was informed that the paper of Justice Romero would take a little time for her to read. And we started at about 2 o'clock or 2:20. And I knew that everybody would listen absolutely to Justice Romero. Now it's 4:10. I thought baka you would not have any more interest to listen to me. So I thought I should wear red to at least force you to look at me and perhaps listen. I am not worried about Professor Candelaria. Because look at him. He is well-dressed and very pogi. At isa pa, lalaki siya. Di ba? Ang sabi nila, when a man stands up to speak, everybody listens. But when a woman stands up to speak, people will look first. And then when satisfied, that's the time that they will only listen.
Look first.
Sir, am I already presentable that you would stop, listen, no, look and listen to me this afternoon? Sir, answer naman kayo.
Easy with taking
Ay,
a
wala
picture.
yata, walang makikinig. Okay. Kahit hindi po ako sinagot, magsasalita na rin ako. Okay. The program states that I am one of the reactors this afternoon. I received the paper of Justice Romero on last Tuesday at about 12 noon, and I started reading the paper. I was reading the introduction part of her paper when I received a call from her and asked if I received her paper. Nasa introductory part pa lang po ako, ay talagang gandang-ganda na ako sa kanyang paper. So I said, yes, Justice, I received it. It's so beautiful. And that ended our conversation. I was not able to finish the paper because I had to attend a meeting, and it was only in the evening that I finished the paper. My general reaction? I was dumbfounded. I was awed. Sabi ko, ang ganda-ganda naman ito. It was beautifully written. Very simple, very informative, and would be understood by those who know the law and those who do not. Hindi po ba? Ang ganda po. Kahit yung mga first year college of law, maiintindihan po. And then I asked myself, Diyos ko po, ano kayang sasabihin ko? And that was what I asked Professor Sedfree. Huy, ano sasabihin natin? And then, she had many questions. Hindi niya rin masagot. Paano ko kaya masasagot? Hindi po ba? So I thought I would just say, Justice Romero, I agree with everything that you said. And I would just go down and leave. Pero sayang naman tong aking red blouse. I said, hindi. Magsasalita rin ako maski konti. Sedfree, konti lang ha. Konti lang. Okay. I was really awed with the historical flashback made by Justice Romero on the origin of our law on family relations. From the pre-colonial times, from the datus and the barangays, where she said polygamy and separation. Ginagawa na pala nung unang panahon? Bakit ngayon hindi natin ginagawa? No? And then how the Spaniards, what they did to us when they conquered us, transplanting their law sa atin po, yung kanila sa Spanish Civil Code. And then, the many radical amendments made during the American regime, nagkaroon na pala ng marriage law at saka divorce law. Bakit tayo walang divorce ngayon? No? And then, the revision, the Code Commission, at marami pang iba na nangyari, giving rise to the Civil Code and the amendments up to the Family Code. Justice Romero was the chair of the committee na tumulong sa atin para maging lumabas po iyang Family Code. Now, let us go to my particular reactions on her paper. Justice, konti lang ito ha, pasensya ka na. Okay. Justice Romero started her topic by citing the definition of marriage under the Family Code, which provides that it is a special contract of permanent union between a man and a woman in accordance with law for the establishment of a conjugal and family life. I think this definition will become a problem nowadays. Modernization, urbanization, industrialization, and perhaps genetics changed greatly the Filipino way of life. Nowadays, we are amazed with what we see and hear about the gay population. No matter how gay people hide in the closets, we realize that gay relationships are now in the open. In fact, meron po ako isang kaso, lesbians, they allege that they are living as husband and wife. They were living as husband and wife. They care for children. How? Fostering or by adoption. Marami pong ang gagaling magnegosyo. They go into business and they acquire properties. But just like any ordinary couple of man and woman, they separate, leaving so many problems brought about by their relationship unprotected by the law. Problema on how to care for the children, on the division of properties. I had a case like that. An application for a temporary protection order. Ang petitioner po ay babae and the respondent ay babae din. And they alleged that they were living as husband and wife, may anak, maraming properties. Anong gagawin po natin sa ganyang mga pagkakataon? It is, according to Justice Romero, maraming problemang nangyayari because of this relationship. But generally accepted, indeed, they are referred to as the closet queens. Hindi po ba? They become victims of violence, bullying. Just like recently, I read a newspaper item that a gay in California was mugged, brought to his hospital, and he died. I don't know if you read about that. And then, I had a friend who had a relationship with another gay, and this friend of mine was so rich. And when he died, he was the one who acquired so many properties for both of them. Aywan ko po kung ano nangyari. The family were asking, what happened to the properties? And that's one of the problems. Okay. Now, this man who died in California, I said, if he had properties, what happened? And there are many gay people who pretend that they are not. And how do they do it? They marry the opposite sex. Hindi po ba si Michael Jackson, sabi, ganun daw ang nangyari kay Michael Jackson? She married Presley, the daughter of Elvis Presley. Hindi po ba ganun ang nangyari? Marami po na nangyayaring ganyan. And of course, Rock Hudson. Hindi po ba? Maraming hindi natin alam na sila pala ay gay. Eh kung si Rock Hudson ay nagpunta po rito, na napakagwapo at ako'y liligawan, ay baka ako'y readily answer yes. But then, gay pala. See what they do just to pretend and to show off to the people that they are not gay people. And what happened? These people, these gay people, only make their lives and the lives of their partners miserable and complicated. Really, that's what happens. But of course, we cannot close our eyes to these gay relationships. Even if we deny it to the heavens, it's there. I believe it is now high time for us to study our laws to give the third sex rights and protection openly that ordinary men and women are given or have. We must not ignore them. We say that hindi tama yun eh, hindi tama. At why is it that even forbidden relationships of ordinary man and woman are still protected by the law? Oh, yung pong may asawa, nakiapid sa isang babae, nagkaanak, abay merong provision dyan on support. Di po ba? On custody. Eh para bakit sa mga relationships of gay people, we do not have any specific provision on how to protect their relationship? We may not be ready for gay unions, but I think we have to do something. Perhaps our lawmakers must think of providing laws on how to protect gay people in their live-in relationships. Ang iniisip ko, how do we do that? I was thinking, well, I'm not a lawmaker, and perhaps those who would be members of committees to amend our laws should study this. Perhaps there should be a law which would require gay people who would enter into live-in relationships with other gay people to enter into contractual agreements on how their property relations would be governed, or if they would have, for example, foster or adopted children. I think we should have this. Now, Justice Romero made mention on the proxy and mixed marriages. I think, may tanong siya doon, hindi ko masagot. Hindi ko alam sagutin. But so what I would say is that our lawmakers and perhaps the UP Law Center should study this matter so that we can have laws to protect Filipinos who might get involved in those situations. Now, Justice Romero went into marriage. But I think I should talk on what we should do before one should enter marriage, before one should get married. As a family court judge, I noted how couples got married without even knowing what they were going into. Walang alam yung mga bata. Basta love, okay. Basta love sila. You know, there was a couple whom I solemnized the wedding. The woman was a foreigner, a white. Yung lalaki, Pilipino. Alam ko may counseling in the office of the local civil registrar, but I always made it a point to counsel. At least mag-isip sila, no? But usually, naku, sabi nung lalaki, abogado pa, I love her, Judge. I love her. I would like to marry her. And then the white lady said, Judge, I know everything about this man whom I'm getting married. I would like to marry him. Eh, wala akong magawa. So I married him. You know, the last information I received on this couple, it appeared that the man brought this woman sa isang probinsya where his parents were residing. Well, masyadong rural. The place was very rural, and the bathroom, she had to use the tabo. The tabo. And you know, I was informed that this lady, during the time that she was there, taking a bath and using the tabo, was always crying and crying and crying. And later on, she left for America. It's true. It's a case in my court. Even experts who appeared before me testified and confirmed that many couples would not even know what they were going into. There is a provision in the family code that before a marriage license is issued, the couple must secure a certification that they attended the marriage counseling. In my experience, yung marriage counseling na nandyan, wala pong halaga yun eh. Walang halaga. Yun daw, short pangaral, and then the certification is issued. And oftentimes, these certifications are bought. They are just bought by the applicants. They would not even attend the marriage counseling. And so, Justice Romero, I'm sorry, I would like to suggest that before a marriage license is issued, there must be a law that would require applicants for marriage license to attend a mandatory seminar on family, children, obligations of husband and wife, property relations, and what have you. And only after they have really attended the mandatory seminar that a certification for the issuance of the marriage license would be issued. So, paano itong seminar na ito? Maybe PhilJA will start working again for that? or maybe the office of the local civil registrar where they file their application, can coordinate with a university or college nearest their place in the preparation of the standard curriculum and in the holding of the seminar. Only after they have attended will the certification, I believe, should be issued. There is also a provision in the family code that even if the local civil registrar would have information or receive information that there is an impediment to the marriage, he would nevertheless issue the marriage license. He would just annotate it there that there is an impediment, etc., etc. I believe that once that the office of the local civil registrar or the LCR would have information on that, siguro gumawa na agad siya ng paraan para hindi na mai-issue at maimbestigahan. Well, according to the information I received, ang sabi, it would be very difficult and dangerous and corrupt. There would be corruption if the office of the local civil registrar would be given that authority. But then I asked myself, hindi ba mas mahirap ipakasal mo yung alam mong may impediment at may information ka? Mas madaling magpakasal kaysa umalis dun sa kasalan, hindi po ba? That is my thinking. Okay. On the legal capacity of marriage, ang ganda po ng discussion ni Justice Romero on the age, marrying age. Actually, I was just talking to Professor Candelaria and I said, the family code has different age requirements for different transactions. Hindi po ba? And this mislead and confuse the public. Kagaya po nito, ito nasabi po, ni Justice Romero. Under Article 234, on emancipation. Emancipation takes place by the attainment of majority which commences at the age of 18 years. Then under Article 236, emancipation terminates parental authority over the person and property of the child and shall then be qualified and responsible for all acts of civil life, save exceptions established by existing laws. But parents are still answerable for damages caused by children below 21 who are living with them. And then those marrying between ages 18 and 21 are required to exhibit with the LCR the parental consent to the marriage of their father, mother, surviving parent, or guardian or persons having legal charge of them in the order mentioned. Itong order mentioned, problema rin din to. No? Marami pong nangyayari na pag nasa Amerika yung father, ang nanay lang ang nandito, nagkakaproblema pag hingi po ng consent. Yung pong even those marrying beyond ages 18 to 21, must submit, 21 to 25, must submit the parental advice of their parents. Kahit daw po, a Quezon City judge observed that yung provision under Article 14 and under Article 25, yung sinasabing between 18 and 21, between 21 and 25, very confusing. Parang pag sinabing between 18 and 21, pwedeng 19 and 20. So, you can just, I don't know if that is really confusing and misleading, but that is what one of the Quezon City judges said. Okay? Now, I also, I said that there are many applicants for marriage license who are not familiar with what they are going into. Today, ang dami pong teenage pregnancies. Hindi po ba? Marami din pong parang early marriages without preparation. Sino po ang nanonood ng telenovela? Angelito, Batang Ama. Narinig niyo ba yun? Nakakita niyo ba yun? Ay hindi prepared. They were students. At kung ano nangyayari sa Batang Ama. So it is my suggestion that perhaps in the college or in the high school and college or universities, there must be a standard curriculum na i-include natin ang subjects on marriage, obligations of husband and wife, responsible parenthood, property relations, and etc. Dapat pong pag-aralan natin yan. I think this is a must. Now, let us go on to the item on terminating the marriage. Justice Romero beautifully discussed the expanded provisions on legal separation in Article 36 of the Family Code. As a family court judge, it had been my experience that very few couples, even if they are in a stormy relationship, they seldom file petitions for legal separation because parang wala kang makuha dun. The marital bond is still there. Yung lalaki, kung gusto mag-asawa, hindi pa pwede makapag-asawa. So it's still there. So what they did during my time, was that they convert the petitions for legal separation into petitions for separation of property. But that is when the problem arises. Kasi, the woman, or maybe the wife, just for the heck of making it difficult for the husband, would say, this is my property, this is my property, this is my property, even if it is excluded under the law. Sasabihin naman niya ng lalaki, hindi yan akin to, hindi yan akin to. It's so difficult. So it is my suggestion that perhaps applicants for marriage or those who are getting married must already agree beforehand on the regime of property relations which will govern their property during the marriage para po pag nagkaroon ng problema later on, hindi na po mahihirapang pag-aralan niyang property. It is very, very difficult to discuss property. There are people who would like to say, iisa-isahin yan. And in fact, there was a lawyer who appeared before me. And after we finished the case, sabi ko, attorney, kumusta na? Ang sabi sa akin, Judge, hindi na po ako uulit. Hirap na hirap siya. Okay. Now, on psychological incapacity under Article 36. Okay? Justice Romero beautifully discussed with us the different decisions in the Santos case, in the Molina, Te versus Te, Suaso. Ang gaganda po ng decisions dyan. But, as a family court judge, and for practitioners, they feel that the decisions of the Supreme Court on psychological incapacity are conflicting and sometimes confusing. No? Practitioners say, that they had actually made an action to dissolve stormy relationships, an expensive, disappointing, and sometimes a useless remedy. There are couples whose petitions were denied. Dahilan sa alam nila na wala na silang remedyo, ignored the ruling of the Supreme Court and still continued to have other relationships. Marami pong nangyayaring ganyan. And meron din po akong case na isa na talaga namang lahat na po yata ng klaseng, ewan ko kung kayo ang naging asawa ng lalaking yun, magko-continue kayong makisama sa kanya. And this was the OSG, alam nyo, during that time, the OSG was required. Often, sila po ang kailangan may certification, pero na iba na, di ba po na-discuss ni Justice Romero. And if the OSG, if the solicitor is newly appointed, masipag po, appeal ng appeal. Appeal po ng appeal. Pag matagal na po sila, marami ng trabaho, hindi na mag-a-appeal. This case, malas. Nag-appeal ang OSG. Nakarating hanggang Supreme Court. And you know, really, the petition was denied by the Supreme Court. The petitioner came to me, crying, and said, Judge, ano pang gusto nila? Ganyan ang asawa ko. Hindi ko na yan pakikisamahan. Magpapakamatay na ako bago ko makisama dyan sa lalaking yan. Marami pong experiences ang lower courts on the decisions, reversals ng the Supreme Court. It is indicated, therefore, that the application of Article 36 must be strengthened and it must balance the interests of those who are actually in need of the remedy and those who will abuse any liberal application and interpretation of the law. But with the modern Filipino way of life and the problems couples now face due to the fast-changing times and hard life, I believe couples must have legal, speedy, and inexpensive remedies available. Just like what Justice Romero said, costs for petitions, for securing nullity of marriages is really, really very expensive. The presentation of private medical experts contribute to the delay and cost of the proceedings. As Justice Romero said, corruption has been a problem. What the practitioners use is packaging of the case. Merong an amount for this, an amount for that, an amount for this, and an amount for that. And it really costs so much. Okay. Just like what Justice Romero said, ang gusto po ng ating batas ay magkaroon ng case-to-case determination if the respondent or the petitioner, kasi either po pwede, is really psychologically incapacitated. Giving the trial courts the responsibility to determine if the behavior of the respondent really falls under psychological incapacity. Marami pong nahihirapan dyan. Kaya po nalaman ko that there is now a bill pending in Congress, introduced by Congresswoman Villarosa, expanding the grounds for legal separation and constituting a combination thereof as prima facie indication of psychological incapacity. Yan po, parang may guidelines sila kung what can be considered psychological incapacity. And this came from case law. Iba't iba pong kasong nagkaroon na po ng desisyon ang Korte Suprema. Okay? Let us go to paternity and filiation. Justice Romero observed that there is a discernible trend in law to favor and uphold the legitimacy of children. But there is also a discernible trend to grant or bestow more rights to illegitimate children. Totoo po yun. There is now a bill pending in Congress, House Bill number 130 of Congressman Al Frances Bichara, which, if passed, would remove and or erase all distinctions between legitimate, illegitimate, and legitimated filiation or children, giving all children the same successional rights without any distinction. Thinking aloud, ang sabi po ng aking friend, bakit pa tayo nagpapakasal? Pareho lang naman pala ang benepisyo kung ikaw'y kasal o hindi sa mga bata. So, hindi na dapat magpapakasal pa. And then, it might also encourage siring of illegitimate children. Okay? On artificial insemination. Indeed, artificial insemination brings joy to infertile couples and others, according to Justice Romero. but at the same time raised so many issues on its control, distribution, and poor administration. DNA will help solve doubts on paternity. Ginagawa po namin yan, lalong-lalo na po sa mga support cases sa family courts. But then, both prohibitive, napakamahal po. And ako po, I had a very personal experience on the beauty of artificial insemination. I had a relative na hindi po magkaanak at tuwan-tuwa po siya when she availed of the artificial insemination but abroad na nagkaroon po sila ng anak. But then, maraming bagay ang dapat gawin according to Justice Romero. We must have laws to protect the donor and the donee of the semen. Semen po ba yun, Justice? Okay. Hindi ko po alam yun eh. Oh. So, alam nyo na yon, ha? Okay. Now, let's go to children in clutches with the law. Okay. Pagka po tayo nag-discuss on children in conflict with the law, we have to talk about Republic Act 9344. What is this law about? Ito po, ang batas na ito ay it seeks to protect two kinds of children. Ang una po, a child at risk, and second, a child in conflict with the law. Sino po ba itong batang a child at risk? Ito po mga batang child at risk are those children who because of their family problems, katatayuan po nila sa lipunan, katayuan po nila sa kanilang pamilya, kanila po mga problema ay maaaring magbunsod sa kanila na gumawa ng mga bagay na magdadala sa kanila sa paglabag sa batas. And who are these children? These children are those who may not have parents, or even if they have parents, they are neglected by their parents. Or those children who are victims of violence, those who are victims of abuse, and those children, yung pong mga palaboy-laboy, wala sa eskwela, wala po sa eskwela, at yung pong mga those living in places wherein there is criminality. For example, in a place wherein there are so many drug problems and criminal behavior. Now, yung po namang child in conflict with the law is the child who has been arrested, detained, and adjudged and convicted to have violated a law. Republic Act 9344 fixes the age of criminal responsibility of children. It fixes the age that a child who is above 15 but below 18 at the time of the commission of the offense and acted with discernment is criminally liable. But those children who are below 15 at the time of the commission of the offense are exempted from criminal responsibility. So, ano pong nangyayari dito? Only those above 15 years and 1 day old, arrested, would be brought before the courts. And those below 15 are exempted from criminal responsibility and they are not brought before the courts. Republic Act 9344 provides for special system and procedures on how to rehabilitate children and bring them up to be good citizens of this country. It's all right for those above 15 because they're brought to the courts. Marami pong ginagawa ang husgado dyan. Gusto pa po niyo marinig ang ginagawa ko nung ako po ay judge na? Just for a short while. This was how, what I did when I was a judge of Quezon City. And many of what I did ay kasama po sa rules ngayon ng rules of children in conflict with the law. children brought before me, whether on bail, recognizance, or under suspended sentence, whether in the institution or in the community, are brought before me for monitoring. This is very, very important. In my court, every 15th and end of the month, of each month, were devoted for monitoring the behavior of these children. Marami po kaming ginagawa. All those involved in the rehabilitation and monitoring of children were all notified to be present in court and give a report on the child's compliance with the intervention program or in the rehabilitation program and the child's and the effectivity of the program. Those who would not appear are given citations or show cause orders. Marami pong ginagawa ang husgado. And if they are found to be okay, so maganda po ang pagtingin ng batas sa mga batang yan. But how about those children below 15 who are not brought before the courts? Sabi nga po ni Justice Romero, yung batang hamog. Maraming ganyan. Marami pong mga syndicates who avail of yung kaliitan po ng mga bata in the commission of their crimes. In the akyat bahay gangs, the children are made to open the windows or open the doors because it's so easy for them to enter the houses. So, we have now debates on whether we would have to lower the age of criminal responsibility of children. I was with the Juvenile and Domestic Relations Court a long, long time ago. Kuha na po yun, pase na. Wala na pong JDRC. Yung nga po, thank you doon sa nagpakilala sa akin, no? Pero sinabi mo, 1962, nahalata tuloy na matanda na ako. No? But at any rate, during that time, when we were with the JDRC, the age of criminal responsibility was over 9 under the revised penal code. And what was our experience? Ang hirap. Because there were so many children involved in even petty crimes, thousands and thousands of cases were brought before the courts. We were swamped with cases. But what happened? Wala kaming mga facilities. There was only one welfare bill, one boys' town, very few social workers, very few schools. Even us in the JDRC, we had to put up a school in the court itself. And we had to put up the tahanan outreach projects and services to assist children. We had to tap many NGOs to assist us. Now, our lawmakers and the public would like to lower the age of criminal responsibility. That's okay. But I will ask, saan nyo natin dadalhin yung mga batang yan? Do we have enough social workers? In Quezon City, there was isa lang po ang lalaking social worker. Suffering pa from disability kahit kasi pilay. I wonder how he would go into those squatter areas and walk. In fact, I have always advised the social workers that every time na marapit ng graduation sa high school, pumunta sila sa eskwelahan and campaign so that those graduating would take up social work. Eh kung mag-social work ka, ayos ba ang sweldo? Mahina. So it cannot attract. And the facilities, do we have enough homes for these children? Do we have enough people? Do we have enough equipment to take care of them? So ako po, ang feeling ko, whichever, kahit anong age of criminal responsibility ang ilalagay natin, depende po yan on how we would implement the law. That's very important. And it will take well-coordinated efforts of all of us and the government and the different branches of government to make it successful. Justice Romero's brilliant discussion on her paper opened our eyes wide on the emerging trends in related laws on family and children, brought about by modernization, urbanization, and industrialization. Indeed, the Filipinos' way of life has greatly changed with her concerns that it is demanded that all of us must work together. May the highest one up there be with the Filipino family, its women and children. Thank you very much.
Congrats. That was so very good. Huh?
Magandang hapon po sa inyong lahat. It's always a delight to cross EDSA and come over to this part of town. It's I have a lot of friends here, don't worry. I've been working with the UP Law Center and the College of Law for several projects, and some of my best friends, in fact, in the field of children's rights, human rights, are in fact on this side of town. I'll be very straightforward with the comments that I'd like to make on 3 points. One, on the substantive aspects of the presentation, matters regarding family and children. The second one is on judicial education. And the third point would be on the impact on legal education today, especially for our law students. I read with great interest, in fact, the paper when Justice Flerida, it's a term of endearment that I always adopt because I like the name Flerida, and she always texts me with Flerida. So, Justice, I was very much excited when you informed me about a month ago about this activity, and I said, with much pleasure, I'm looking forward to a paper. And true enough, I'm reminded of also an equally very good lecturer in international law, Rosalind Higgins. If you read her paper or a book, it's really not much in a very technical way like Brownlee, but written in a very conversational way, which makes a very technical field of law so simple. That's how I found the paper. It's very conversational and yet very challenging, and without having to offend, in fact, certain positions on very key issues like RH Bill. That's how I found it very, very interesting. It is also an opportunity for me to reflect on the work that is probably my comfort zone, where Justice Flerida has been a part of. That's the Convention on the Rights of the Child in the Philippine legal system, where you recall, Justice, we requested you to be part of the panel of experts to guide us in drafting that UNICEF publication on the CRC. And it was my initiation basically into the field of children and subsequently on matters of family law. So I would like to really commend you for such great foresight that you have as a member of the commission at the time, looking at the family code and anticipating some very perplexing questions. Of course, the questions may not be readily answered, as I'm sure the reactors were not expected to answer your questions. I was telling myself I already have about 20 to 30 thesis topics assigned to my JD candidates who are going to prepare their thesis very soon. So it's a material that I'm going to pass on to them because I really have identified a lot of thesis topics immediately. I'd like to cite some matters on the substantive aspect, Justice. One is in relation to my experience having been with the Inter-Country Adoption Board for some time, and it's good that our point person for the inter-country adoption is here, because the question that you have raised before on matters, let's say, of same-sex marriage has in fact also visited us at the Inter-Country Adoption Board early on when this law was adopted, because quite a number of our applicants at one time, when the new law in the Netherlands, on same-sex marriage came about, were really quite apprehensive, with Filipino children probably landing with couples out of a same-sex marriage. At that time, we were already grappling at the Inter-Country Adoption Board because many of those who are running the child placement, child caring agencies in this country really come from the religious sector. And whenever there's a matching of children at the level of the matching committee, their social workers would be very, very hesitant to actually accept applicants from other countries who would actually allow same-sex marriage in their jurisdiction. So it was really a problem in various aspects, even the adoption of Filipino children. The other point I'd like to emphasize is on the removal of the distinction between legitimate and illegitimate children. Well, of course, this is born out of our accession to the Convention on the Rights of the Child, as you mentioned. We were the 31st party, one of the earliest, in fact. And it's a document that perhaps many countries will not argue much against, except perhaps for the implication on matters of family law. And the removal of the distinction, in fact, was the subject of a survey that we did with the Council on the Welfare of Children sometime in the 90s with Director Divina Kaalim at the front of the survey. We did this with Professor Balane, Joey Chave at that time, and other members of the legal profession. And as early as that period, we found out in the survey that it was about 50-50. We did a nationwide survey on this, on whether you would want to remove the distinction between legitimate and illegitimate children. But the way to interpret it is, in fact, on one hand, there were about 50% of our population who would want it removed, but perhaps on the level of the impact. Right? They were worried, for example, on the impact on the institution of marriage. And that was very much the concern also of Judge Pison earlier. But one of the compromises, perhaps, to interpret it is to look at the effects. And that is where the direction has been the past few years. We may not be able to remove the distinction totally, no? But looking at the impact on the illegitimate children, that is where progress has been. It may go a little further, no? Now you have the use of surnames, no? Of the father. But it may even go much further there. But looking at the removal, that may still be a little away. Another point I'd like to make is the one that really would probably figure in the RH bill controversy on the matter of the right of the unborn. Okay, it was mentioned that the Constitution, in fact, protects the unborn from the point of conception. Now, you go to the Convention on Rights of the Child, and there's a history to the 9th preambular provision of the Convention on Rights of the Child, where protection is extended, as mentioned also in the paper of Justice Flerida, of a child before as well as after birth. That was a preambular clause that was deliberately included by our representative to Geneva at that time when the Convention on Rights of the Child was being deliberated, simply because there would have been a problem on the provision on right to life, which is a specific article inside the Convention on Rights of the Child. And the Philippine representative at that time pointed to the constitutional mandate that protects the life of the unborn from the point of conception in order to reconcile our commitment under the Constitution and in light of the Convention on Rights of the Child. That, I think, is a perspective that perhaps may not have been fully ventilated in light of course, the discussion at this point. So the perspective of the child may be worth looking into in that regard. On the juvenile justice issue, this is one close to my heart, close to Albert Muyo's heart, one of your professors here. We worked together here when he was at UNICEF at that time. We work on the NGO side, in fact, hammering out the Juvenile Justice Welfare Act until it became law. We knew the possible problems arising out of it, and Justice Flerida pointed out very clearly the matter of resources, the matter of programming, the matter of training. It is something that we saw as a very good law. Good law because it approached it from a multidisciplinary perspective. It looked at the different pillars of the justice system. In perhaps a very seamless way to implement it, it will be the ideal. We have seen models in different parts of the world. But of course, what we are encountering really is probably barking at the wrong tree right now. Amending it perhaps, lowering it back to 9, probably may not be the right solution. We probably have not yet seen the enforcement aspect and how we have addressed, in fact, those who are capitalizing on this, the adults. That is perhaps where work needs to be done, and looking at the programs that should be made available in light of the purpose of the pillars of the justice system. Let me now turn to judicial education. The paper dealt a lot about the questions arising on different facets of family law, including laws related to children. One hat I'm wearing is, of course, shared also by Judge Bison and other members of your law faculty, and that is judicial education in the context of the Supreme Court, Philippine Judicial Academy. There is a law that was supposedly, again, intended to be very, very good law for the purpose of creating family courts. At this point, they're still designated. There was a very ideal setup under Republic Act 8369, which perhaps may have reflected the old Juvenile Domestic Relations Court in a different fashion. But the idea was really to have a one-stop shop service. That's the Social Services Counseling Division. It was intended to address all the difficulties, perhaps, that may be encountered by any party coming before a family court judge. Or in the olden times, perhaps it would have been the Juvenile Domestic Relations Court judge. Part of the problem of expense, for example, could be addressed if you have a fully functional social services counseling division. We know that even in nullity cases, it became very expensive for those who are trying to petition the court. Even on matters of psychosocial assistance, it also becomes very expensive. And if the ideal setting is in place again, and it's again a function of resources, then perhaps the questions raised by Justice Flerida in her paper would be addressed more fully. There are trainings being done now to the extent available through the Judicial Academy, and we think that capacity building, continuous capacity building for our judges and other court personnel will be an important complement in order to address the issues raised by Justice Romero. The third point is on legal education. It's one, again, close to my heart because one of the products of our curriculum development at the time at UNICEF was really offering it at the law school level. It was very challenging to offer, for example, a children's rights course, because you would have to tap other persons, perhaps a psychologist, a social worker, no? Even a law enforcer, for that matter, a prosecutor, to be part of your team. It is one that requires us to be creative in trying to have curricular offerings now in law school. I always like reading the quote outside here at your hall on teaching law in the grand manner. I always say, yes, I think law school should teach law in the grand manner. Creativity is required of the teachers, I think. Quite a number of us in the legal profession who are just being initiated into these new concepts that Justice Flerida had mentioned, arising out of developments in science, development also in, let's say, globalization, urbanization, would challenge us as lawyers to be perhaps more open to adapting the curriculum and even our teaching methods instead of just terrorizing our students. So we are challenged, even as legal educators today, to perhaps be more abreast with developments in other disciplines. In a university like yours and in the Ateneo, you would have very competent people in the other departments. It is just waiting to be tapped. UPPGH, Child Protection Unit, is a very remarkable institution that we work with. We are hoping that other institutions also could do the same. There's a lot of gold mine out there. Of course, excuses to the anti-mining advocates, no? But there is a lot of talents that we can tap as lawyers, as legal educators, in order to pursue a more creative curricular offering. The questions that were raised by Justice Flerida, of course, cannot be answered overnight. But she was right in raising these questions because in the end, we may have to look at it from a cultural perspective. As a society, we may ask, to what extent is Filipino culture going to be shaped or influenced by other cultures in that regard? How do we define our own culture? We have seen the history of layers and layers of legal systems in the past. There are times we revisit our pre-conquest tradition and discover that perhaps there may be something else that we may be able to apply in order to realize more a Filipino culture. But things are fast developing. In the realm of law, law tends to be, in fact, dragging behind the other disciplines. Again, as lawyers and law practitioners, this is a great challenge for us. And as a society, culture perhaps will begin to shape more the way that lawyers and practitioners think, including our judges and justices. And this is the biggest challenge for us. How do we now cope with all these changes around us? Our children will be facing these issues. They are the ones who are going to answer these questions. How do we prepare them? As part of the judiciary, as part of the legal profession, as part of the academia teaching law. This is my real appreciation for the paper, Justice. You have given us a real set of, I think, menu to think through. And we hope that you will continue to guide us with the foresight that you once exercised when you envisioned the family code before. Maraming salamat po, Justice.